Good afternoon, students. Please confirm am I audible? All right. So yesterday we discussed about the few fundamental points about the charge. And one of the facts about the charge is in law, charge will be considered as charge only in the case when it is registered. Without registration, it will not be considered as charge. And it is compulsory for the company. Look, it is mandatory. It is compulsory for the company to register the charge. If charge is not registered, then it is punishable under the Act. Now, what are the provisions and how the charge can be registered? Let's understand this. Okay. Before I go on, I think all of you are clear with the concept called what is the meaning of charge, types of charge, crystallization, and the charge registration is compulsory. All of you are clear with this? Hello? Please confirm once. All right. So how the charge can be registered? That's now, yeah, Shamika, that will come. That will come. Don't worry. Now, what are, okay, let me take that point first of all, that what are the different reasons for crystallization, the causes for crystallization. Okay, causes for crystallization. Now, you tell me, in this question, what we supposed to write? Okay, causes for crystallization. Why any charge holder? Okay, before I go with that, let's clear with this concept. What do you mean by charge holder? Is it company or the lender? Hello? When I take, yeah, it's a lender. So why charge holder wants to go for crystallization? So obviously there should have certain reasons. So write down point number one, reasons for crystallization. Write down reasons for crystallization. Point number one, when company ceases its operation. When company ceases its operation. You tell me one thing, when company ceases for its operation and when bank or lender comes to know that company is about to shut down, will it wait for the declaration of winding up or they will go for crystallization? It is quite obvious. It is quite obvious that they will not wait. They will not wait. They are definitely going for crystallization because already you know the company now doesn't have any operation, that trading got shut down. Why should you wait? Directly go and apply for crystallization. Point number two, if you look at it, it talks about when company decides to be wound up. Now look at the words. When company decides to be wound up and this news is broken out in the media, now will you wait till the application is filed with the court or you will initially directly go for crystallization? Huh? Ishika, Shamika, tell me. Immediately you will apply for crystallization. Third reason is very important. Third reason is very important. When company violates any of the terms mentioned in the contract. For example, it was written that per month you need to pay the installments, EMIs, and company has not paid the EMI since last 5 months. Now, will you wait or you will immediately go for crystallization? Answer it. Obviously, you will go with the crystallization. Got it? All right. Fourth point, crystallization can be exercised or may be exercised. Yeah, maybe it's good. Exercised for any other reason as mentioned in the agreement. So it can be exercised for any other reason as mentioned in the exercise. These all are the reasons, students, why the company would like to go with the crystallization. I hope it is clear, right? Under what circumstances it goes. Fine. So let's begin with now the new concept, and that is registration, modification, and satisfaction of the charge. But now we are practically going to face the process. All right. Now, look, the governmental website from where you can access the company law contents. That website is ebook MCA. Ebook MCA. You click on that, and the left hand side you see here there's the apps. In the apps you can select a lot of apps, including you can check it over here, the Chartered Accountants Act, Company Secretary Act. Okay, look at this. Chartered Accountants Act is one of the most ancient act over here. Simply click on the Companies Act 2013. Left hand side, all the chapters are there. Sometimes, if you want to read the exact words with amendments, you should always go with this chapters. All right. And look at this chapter number 6. It is registration of charges. Are you able to see this? Hello? Look, already we have covered the chapter number 3, part 1. That was the prospectus and allotment of shares. Private placement, I will tell you later on, but now this is the point, chapter number 6. Simply click on this, so you will see all the different sections. Section 77, 78, 79, 80. Till 87 we have sections. Till 87. Alright? So before I start, my request to all of you is start writing all this section in details, that what is the section 77 is all about, 78 is all about, 79 is all about, 80 is all about, 81 is all about, 82, 83 and all that. You can take the snapshot of that. Simply click on this. Please do it. And once it is done, at the word done, then we will start the understanding of each and every sections here. All right, do that. All right, so are you ready to go with that now, students? If your answer is yes, we can begin with that now. Let's begin with now registration of charge. So first point is over here the duty to register the charges. Two minutes. Meenakshi. All right. Still some students are writing. Now, all those who have completed the writing, my request is you please note it down that which sections are very important for your exam. That means so far the exam is concerned to what kind of questions they have asked so far out of this section number. So first of all, section 77, that is the hot favorite section for ICI for asking the questions. After that, section number, this is it. Section number 80. 80 is also very important. From this also there are a lot of questions. Section 81, registered capital, that is also very important. Section number 83, that is also very important. On that basis also the question was there. Okay, these many sections are most important while you're doing the question. Okay, so are you ready with that? So section 77, now section 77, it is the answer for what kind of question? So let's print the question first of all, and then we will go with the solution. So write down here the question first of all. Question, how the things are going on. Suppose there is a company called Neha Limited, and this company wants to get a loan. That's why it applies to one of the most reputed company in India, that's called the HDFC Bank Limited. HDFC Bank Limited. It applied for 50 crores rupees loan against the mortgage of 70 crore rupees in movable assets. It is almost 100 days, but charge is not registered yet. Can now company register the charge? Explain with the provision. Explain with the provision. Explain with the provision. All right. So let's take the overview of this particular question. I think question itself is clear to all of you, isn't it? Hello. I hope the question itself is clear to all of you. All of you are clear with this question? Hmm? All right. So let's begin with the solution now. How do these things are happening here? So fundamentally, what law says, I will give you the what I can say reference of the section 77 as well, so that we can understand each and every paragraph. But how these things are going on, let me give you the overview of that. Point number one here, law says the moment when charge is created, charge is created. Now the question is, how will you get the date of charge? So basically the date of contract of taking the loan, that is the date of creation of charge. Are you getting me? Date of contract, and obviously in today's market, no company or no bank will give the loans without any mortgage. So the moment when charge is created, as on the date of contract, as on the date of contract will be considered as registration of charge. Sorry, creation of charge. And once the charge is created, both the parties means which are the parties here? Company as well as charge holder, they have 30 days to register the charge. Understand? To register the charge. So maximum these people have 30 days to register the charge. Within 30 days, by hook or crook, they must have to complete the registration of charge. They must have to complete the registration of charge. They must have to register the charge. Now the question is, what if within this much time they could not register this? Then what are the consequences? There can be possibilities that within 30 days they could not register this. So now students, you understand, earlier they had 300 days, 300 days from Shamika's daughters. Yeah, I will tell on that. I will tell. So now if they could not register within 30 days, then what is the provision? So the provision was that from the creation, understand, from the creation, okay, if they could not register it within 30 days, but now they can register within 300 days from the creation. Within 300 days from the creation. Just a second. There is just one small amendment has taken place. I need to just tell you about. Look, what I'm saying is this 300 days was the provision, but this rule doesn't apply to your exam. Your exam, mind well. Remember, this is the old provision. This is the old provision. Here there is an amendment. Here there's amendment. So be very careful while doing these amendments. And just a second, just a second. Yes, I got it. Just a second, guys. Just a second. Okay, sorry for the inconvenience. Yes. Now, what is the amendment which is applicable for your exam? Let's understand this. So earlier there was 300 days, but now there is amendment taken place in the year of 2019. In the 2019. According to the amendments taken place in 2019, now all charges can be categorized into two parts. Charges can be categorized into two parts. Part number one and part number two. all those charges which are created before this amendment, before or up to amendment 2019, for them the old provision will apply. Old provision will apply means all those charges created till the amendment taken place, then if they could not register within 30 days, the next period is 300 days from the creation. But what about those charges which are created after amendment 2019? Then now be very careful. It is not 300 days, it is 60 days after expiry of 30 days. Got it? They are 60 days from the creation. So did you understand that earlier it was 300 days, but after then it has become only 60 days. Okay, let me tell you again, guys. Actually, the duty is to create within 30 days. If you could not, then again you have 300 days from the creation. So technically speaking, you have how many additional days? How many additional days? Can I say it is 270? Because no Ray, not 330. Sonia, it is 270. Thank you, Shamika. You understand that already it was 30 days. You had a duty to complete this procedure within 30 days from the creation. So you go in this way. All right. Suppose this is the timeline where this is the date of creation here. This is the date of creation. After creating this, you have this 30 days for completing. But if you could not complete this, then what law says that from this creation you have 300 days. So as far as the additional days are concerned, can I say it is 270? I hope this diagram is clear to all of you. All right. Part 2, if the charges are created after 60 days, then what is the provision? Like after amendment 2019, then it is 60 days from the creation. So now, what are the additional days you can enjoy? What are the additional days you can enjoy? Only 30. So please remember this concept. Here it is 300, but it was for them. This is the new amendment taken place, and that is only 60 days will be considered. Only 60 days will be considered. Nothing much in that. Now, how to register? We have said you should register, but how to register now? How to register? How to register? So obviously, look, registration of charge is nothing but it is intimation either by company or charge holder. Now Shamika has had this doubt. Sir, whose responsibility it is to register the charge? Is it company's duty or it is charge holder's duty? So if you read section 77 carefully, it is clearly mentioned that it may be registered by either of the parties. So it may be registered by either company or by charge holder. It can be registered by anyone. There is no any specific rule that only company should go or only charge holder. Either of the parties should go. But in today's environment, you understand that lenders are not easily relying upon the companies. What do you think? They simply relying upon the companies? That company is so good, okay, let's trust on it and let it go. No, they are not relying upon this. So that is why all the charge holders are going for the registration, but law doesn't specifically says about it. According to the law, it is up to you. You want to go for a company, it's fine. If charge holder wants to go, it is also fine. So either of the ways they can go. Now it is very interesting part how they can go. Okay, so what is basically registration of charge? Can I say that registration of charge is simply nothing but You are informing the ROC that you had a contract for the loan. So it is basically intimation to ROC that you had a contract for the loan and what kind of securities had been given to the charge holder. So if you were the lawmakers, how would you have made, how you would have drafted the procedure for intimation? Can I say just the form? Company as well as the charge holder needs to download one form from the ROC website. Both of them must have to study that form in detail, fill the details. After filling the details, it should be signed by both the parties. What do you mean by signed by both the parties? What kind of signature will be used? So the signature, it is the digital signature will be used. Are you getting me? Are you getting me? The digital signature will be used. Okay, do you want to see the practically how digital signature looks like and how the things are going on? Hello? Hmm? Um, okay, so what I need to do is I have a server. I need to open my office server. Oh, wait. And right now, some of my clients' digital signature is attached there. Let me show you how digital signature actually looks like. Can you see this? Oh my God, I was on mute. So whatever explanation I gave about these tokens, did you understand that or not? Digital signatures are not the scan copy, but it is the hard token, very much secured, very much secured. These are the digital signatures. These are the digital signatures. All right. Now, are you able to see this logging? एक minute, just a second, Nilesh, just a second. Are you able to see this particular screen, server screen where I'm getting logged in? Yeah, just wait for a few couple of minutes and I will show you how digital signature can be used for certain matters practically. All right, great. All right, guys. So let me show you how the digital signature token looks like. Look, this is not my screen. If you're thinking that this is Chirag's screen, no, it's not my. It's not a my computer. This is my office computer. All right. Look, if I minimize, can you see this desktop can be minimized over here? Hello? If I minimize, this is called my screen. This Excel is our existing laptop or the computer. And this is my office screen. Right now, few digital signatures are attached in this server at Ahmedabad. So this is Ahmedabad server. So how we can process the digital signature? Let's have a look into that. Why it's coming slow? How many users are there? All right. Okay. So click on here, income tax department. After then, click on the login and put, come on, come on, come on, come on. Come to this part, it is PAN number. Suppose I put my PAN number over here. Continue. After putting PAN number, I want to set the forgot password. I want to reset the password. All right, and my user ID is again this one. I'm clicking on the forgot password. Can you see these three different options? These three different options. And the second option is upload digital signature certificate. All right, digital signature certificate. I simply click on this. Continue. It is the new DSC. Continue. This is the DSC software. Continue. And look at over here. Can you see these three different tokens over here? ePass version. So right now in my computer, my server, how many digital signatures are attached? Hello? How many digital signatures are attached? 3. If anyone just pulls out that particular pen drive token from my server, then it will be removed from this. If I click on this name, let's see that whose name is written over here. Look, Valabhai Ramabhai Patel Boka. So it is his digital signature. If I click on the second part over here, and then I click like this, Vadabhai Hengolabhai Patel. Third digital signature belongs to third person. It would come. Dalabhai Khemajabhai Rabari. I put the password, and when I sign in, guys, this is how the signature works. This is how practically the signature works. So don't ever think that digital signature means you have to sign in a plain paper, scan it and upload to any website. That is your digital signature. That is not your digital signature, Abhay. That is the scan copy of your signature. Are you getting me? Digital signature doesn't require any pen. You understand, guys? This particular token, it is so secretly, it is just like a secret code. It is just like the secret code. And the moment when you put your secret code over here, secret code here, it would work like your actual signature. And the government of India is relying upon this particular system. Okay, now let me come to my own system. Let me come, let come out of this. Yeah, killer bhi ho jaan. Let me disconnect myself. No problem. All right, so this system now I have come out of that. Now, practically, if you can check it over here, how we can go for signature of charge. Let's go with that. So guys, look at the section number 77, what is written over here. We have to go for charge, and charge can be registered by using certain forms, right? Students, I'm extremely sorry, some borewell work is going on nearby our apartment, so this annoying sound is coming, but I hope you people are comfortable with this. Are you? I hope you're still comfortable with this. I hope so. Okay. So form will be signed by both the parties. How it will be signed? By affixing the digital signature signed by both the parties with digital signature. Now, what kind of form will be used? So we have two forms. First is charge one, or not a charge one, it is actually CHG1, that is the first form, and CHG9, that is the second form. These two kinds of forms are used. CHG1 is used for charge created in favor of debenture holders. You tell me guys, can I call the debenture holders are also lender for the company because they are giving the loan? Obviously, it is a long-term loan to the company asking for certain security. I am asking for certain security. They are asking for what? Can I say debenture holders are also charge holders when the security is given in that favor? All right. And CHG9 is used for the charge holder other than debenture holders. Other than debenture holders. Now let me go with more practical. Look, practically if I show you the form and all that, so it is very easy for you to remember the procedure. So are you willing to see that how the forms looks like? Both the forms looks like? How these forms looks like and what are the details, because in one of the attempts, I don't remember exactly the attempt here, but this question was there that what are the contents of the charge 9 form for the charges? What are the contents? That kind of question they did ask. What are the contents? Wow. All right. So I cannot get a good response. Are you people willing to understand, like see the practical of charge forms? Do you want to see the charge forms? All right, let's go with that. So look at guys over here. This is section 77. Uh, Let me change here the theme, I guess. Yes. Are you able to see this contents over here? All of you? So let's understand guys what is written in the section 77. It says that it shall be the duty of every company creating the charge within or outside India on its property or assets or any of the undertakings, whether tangible or otherwise. So look, this paragraph of the section 77 answers one question. The question is it always tangible assets upon which the charge should be created, or it can be intangible assets as well? So understand, sometimes there can be the question that what are the assets, right? What are the assets upon which the charge may be created? So first, it can be within India assets, it can be outside India assets, it may be tangible assets, or it may be intangible assets, or even it can be future assets. Write on this note, guys, it is very important. These 5 kind of assets, charge is compulsory to be created. Now, what do you mean by future assets? Can anyone give example of the future assets? Can I say uncalled capital of the company? It is future assets. Uncalled capital of the company, it is future assets because that is for sure to come. that is for sure to come. So if company goes to the bank and asking for the loan by securing uncalled capital as security, is it allowed or not allowed? That is the question. Is it allowed or not allowed? Answer would be allowed, as well as company must have to create the charge on this, must have to register the charge on this. So I hope this is clear to all of you. Hello? So it is written that it shall be the duty of every company creating the charge within or outside India on its property or assets or any of its undertakings, whether tangible or otherwise, and situated in or outside India. It is also the duty to register the particulars of the charge signed by the company and the charge holder together with the instruments creating such charge in the charge form. What are the charge form? I will show you that. On payment of such fees in such other manner with the ROC within 30 days of its creation. Within 30 days of its creation. Now here, what are the charge form? Let's click on this. If you click on this, look at here, guys, entire procedure is explained. And it is written that for registration of charge, according to section 77 and 78, what is 78 and 79? I will tell you later on. The particulars of the charge together with the copy of the instrument, if any, creating or modifying the charge for form number charge 1, that is CHG1, and form number CHG9. So charge 1 is for the, oh, I'm sorry, I think I have made a mistake, guys. I have made a mistake. Charge 1 is for other than debenture holders. It is my mistake. And charge 9 is for debenture holders. I want all of you to just correct it. I'm sorry, it is my mistake. So form number CHG1 is for other than debentures, and CHG9, it is for debenture or holder. So let's click on the form number CHG1. So the moment when you go over there, just a second, I need to download it. Look, the form is so secure that you cannot see just from normal eyes. Look, on the web browser, it will not open. When you click on this PDF file, where it is? Yes. All right. Please confirm, are you able to see this PDF file? Hello? Can you see this PDF file? What no? If file means the PDF layout is open now. Look, when I click on the allow, when you open this file, it is actually one small software. Look at the magic now. Click on allow. And this is your CHG1 practical file. I do not know whether you have seen any fillable PDF file, but trust me guys, this is fillable PDF file. Can you see this? I can fill the data in the PDF file. Did you ever thought even that a PDF file can be fillable? But yes, it is fillable. Now look at, I need to provide here the CIN. CIN means what here? What do you mean by CIN? So CIN means company or corporate identification number. Let me take any companies, suppose Tata Motors CIN. So what is the Tata Motors CIN? Let me tell you here. So if you go here, can you see the CIN of the Tata Motors? Look at the magic of this form now. All right. Students, I want to take your consent event. That are you really willing to see all this detailed procedure, or I should cut it short and I should focus on the content? Do you really want to see all this? This practical session, I think, will help you to remember the concepts. But if you do not want to see this and directly you want to go to the contents and just like a question answer solution, then I can complete my syllabus very soon. And you want to see now? Okay, fine. Thank you. Trust me, guys, I charge 18,000 rupees for the 3 months to teach to the practical students. Yes, in my firm, there is another department where if anyone wants to learn practically all these ROC compliances, we charge fees from them. We charge fees from them. Simply click on this point, click on the prefill. But when you click on the prefill, it will not directly affect. You have to make certain security considerations. Yeah. This will close and it will reopen. It will reopen and then look at the magic now how the things are going on. There was an error. What kind of error? Access is denied. This should not happen. Yes, now it is opening. Wait, can you see this? And now look, this form is already number is already there. If I click on the prefill, prefill means what? What do you mean by prefill? Prefill means all the details will automatically gets filled up, provided your number should be correct. So look at the magic now. If I click on the prefill now, did you see that all the details automatically filled up in the form? Look, Tata Motors Limited, its address, all the details, and did you notice this? All right. So certain details are automatically filled up over here. Fine. So this is the beauty of this form, right? Now let me tell you that what are the details about the charge you need to put in that. So corporate identification number, GLN, company's name, its address, email ID. Now this is for what? Whether you want to use this form for the creation of charge or modification of charge. So did we have the content like modification of charge? That point was also there, na modification of charge. Modification of charge means if you want to change the conditions of the contract. Let's say earlier the rate of interest was 15%, but now new rate is 18% with the consent of both the parties. Can I say? Can I say that it is modification in the charge? So modification in the charge means you are changing the terms and conditions of the charge. Now you have to select whether this form is for what reason. Is it for the creation or it is for the modification? So I will click on it is for the creation. Who is the applicant? Shamika, this is the answer. Whose responsibility? It can be done by both of. So you can select the company, you can select the charge holder. It is up to you. All right. So let's click on the right now the company. Date of the instrument creating or modifying charge. So I can put like today. Today is which date? 20. Today is 20 now, if I'm not wrong. 19, I guess. So 19 January 2022. You can put this. Nature and description of the particular. So you have to put the certain particulars over here by typing something. Whether charge is created or modified outside India, answer is no, it is within India. Now these all are the types of property upon which you have to provide. Like it is on uncalled share capital, immovable property, floating charge, any other property, it is on patent, trademark, book debts, goodwill, license under patent, calls made but not paid. Under what property you people have created. So I will click on the immovable as well as I will click on the book debts as well. Whether the consortium finance is involved, answer is no. Consortium means one company is getting the finance from more than one banks under a single project. That is called the consortium finance. Is it possible that two or more banks are joining hands together and they are financing only one company? Possible or not? Is there any joint charge? Answer is no, no joint charge. Joint charge means more than one company. Number of charge holders, only one. Now here you have to provide about the details about charge holder. Is a national bank, scheduled bank, private sector, financial institution, cooperative bank, individuals, others. So let's put it like a scheduled bank. Now when you click on the get list of the charge holders here, from which bank you look at the form my reference. It contains the name of all the banks. How beautifully it is designed. This means there shouldn't have any kind of error, even spelling error, even the dot error while you do that. So all kinds of the banks are here. So in my example, it was HDFC Bank, isn't it? So this is what I'm going to select this. All right. So name I will type it over here HDFC, and address line I will type and something like this and something like that, and the state I will type like it is Gujarat, of course. Pin code I will put like the 3824. Email ID I will put like a@email.com. Right. I do not want to put all the details. It doesn't have the PAN number. Okay, invalid form of email. So 123@gmail.com. Okay, so compulsory you have to put the PAN number. Let me put my PAN number over here. OPPA092. Amount involved. Please ensure that you have entered the correct amount already. It would be 50 crores, rupees 50 crores only. Mention the details, principal terms and conditions, all that rate of interest, terms of repayment, nature of facility, date of disbursement, what is the margin money kept. Margin money means total security is 70 crores, but the loan taken is 50 crores. So 20 crores rupees is considered as the margin. If it's a debenture holder, how will we select the name? Jayesh, have you heard about debenture trustee, who are the representatives of all debenture holders? So if there are thousands of debenture holders, but trustee will be one or two only. So one of them will sign. One of them will be signed. It's a CHG one, yes, of course. So extent and operation of the charge and others details. So till this, guys, if you look at the lot of details we're providing, property details, address, blah, 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 short particulars. When any assignment comes for filing this form, we chartered accountants are charging more than 5,000 rupees for one form filing, because it should be filed with a lot of proper care, isn't it? After the instrument of creation or modification of charge, that means it is the document, the contract, entire scan copy of contract we have to attach here. So look at this. When I click on the attachment, suppose this is what is I have attached the PDF file entire, and now this is here the declaration and the signature panel. So here I have to click as I declaring resolution number so and so 50, dated so and so. I have to put like that, and look at this digital signature with the director and all that. Did you see if I click on the digital signature, and if the digital signature is attached in my computer, all that names will be appeared. I need to password and it will get signed. It will get signed. So it should be signed by the manager of the company. At the same time, it should be signed by the charge holder. So you have to provide the charge holder details and its digital signature. Not only to that, it should be signed by either of this party, either chartered accountant or cost accountant or company secretary. Why chartered accountant needs to sign this? So that he is confirming that no detail is manipulated. All the details, entire detail is perfectly fine. Are you getting my point? Hello? Hello? So guys, this is the charge chapter, and after having this, you need to upload this form with the ROC website by paying certain fees. And when this form is uploaded successfully and approved by ROC, this data will be reflected. This data will be reflected in the company's master data under the charge. I hope students, you have practically understood everything, including the form. Do you want to see how CHG 9 looks like? Hmm? But I will not give that much time in that. Take a simply, I will tell you, because most of the details, what is provided here will be same. So I will not waste my time in that. Okay, CHG 9 now we are understanding. All right. Open, yes. So are you able to see the CHG 9? I will not go for that procedure again. Just देखो कि how does it look like, and so again the same thing, CI and all that email ID. This form is for creation, modification, or rectification. Types of debentures, bond or any instrument debentures, stocks. Types of debentures you have to provide over here. Get a list of the charge holders, number of trustee or debenture holders. If trustee is not appointed, you have to provide a list. Then city details. Again, you have to select the type of property over here, particulars of the property, rate of interest, and all that details you have to provide, including margin. All right. Then attachment, instrument of that declaration. But understand over here, declaration will not be made by any charge holder. It is written that debenture holders, debenture holders. Designation part, and at the end it would be signed by any chartered accountant or cost accountant or something like this. So almost if you see, the form are almost similar. Just a note here. Meenakshi, if you look at it, it is clearly written in whole time practice. So only practicing chartered accountant is allowed to do that, who is holding the certificate of practice. Right? So all those who are working in the company, they don't deserve to have a certificate of practice with them. And that's why they are not eligible. That's why they are not eligible. Hey guys, type the word clear if you have understood a little bit part about the section 77. Come on. Clear? So now let's understand the contents. Now look, once you people are practically clear about how practically the charge is formed, trust me guys, now this will be the fun for learning this entire chapter. And if this question is there in your exam, trust me, you will feel more glad while you're writing the answer. So now let me go with this. If you have any problem with the paragraph, please let me know this. So I'm now just simply reading the points, simply reading the points. It shall be the duty of every company creating a charge within or outside India on its property or assets or any of its undertakings, whether tangible or otherwise, and situated in or outside India, to register the particulars of the charge signed by the company as well as charge holder in the particular form on payment of certain fees in the manner with the ROC within 30 days. Provided that the ROC may, on application by the company, allow such registration to be made. So ROC may allow, may disallow. If it doesn't like, if it finds that certain particulars are fraud and actual charge is not created, then ROC may say no on that. In case of charge created before the commencement of the company's amendment ordinance 2019, Then you tell me guys, if charge is created before 2019 amendment, then how many days are there? If you could not file within 30 days, then it is 300. Are you getting me? So it is within period of 300 days of such creation you have the time. But what is the difference then 30 and 300? Simple. If you are filing within 30 days, fees will be normal. But if you are filing it after 30 days, then additional fees will be paid. Not a penalty. I'm talking about fees now. After that, it is written that in case of charge is created on or after the commencement of the amendments, then next period is within a period of 60 days of such creation on payment of such additional fees. You have to go. So these two paragraphs are the new amendments, as you can check it over here. Provided further that if the registration is not made within the period specified, then guys, you have to start paying the more additional fees. So what if you could not do within 300 days? What if you could not do within 60 days? Then you have to pay more additional fees, and that fees is almost tantamount to penalty. Tantamount to penalty. Are you getting me? If you could not file within 60 days, then ad valorem fees will be paid. What do you mean by ad valorem? Ad valorem fees means proportionate fees. Proportionate fees means what? It would be now percentage basis. 5% on the paid up share capital or authorized capital, 2% of the total authorized capital. So if your authorized capital is 50,000 crores, just imagine 2% of 50,000 crores goes how much? So are you getting me, students, that how they have not said that you will be punished, but the fees are too high, too high. Ultimately, that becomes penalty. Hey, type the word clear if you have understood all the contents of section 77. Okay. Now, this paragraph is very, very important. And over here, there can be one small question. Before I go to this question, let me tell you that what can be the question here. Suppose there's a company called Shamika Limited. This company taken the loan of 50 crores from a bank called State Bank of India, and charge is not created. Now SBI is asking for 50 crores along with interest, and Shamika Limited says that as the charge is not registered, charge is not registered, this agreement is void. This contract is void. And as it is void, the terms and conditions written in this agreement are not binding to Shamika Limited. So that is what my question over here is, that whether is it binding to the company or not? Answer it. Is it binding to the company or not? What do you think? Is it binding to the company or not? Is it binding or not? Okay, Meenakshi says no, Jay says not binding. Okay, Mahima says yes, it is binding. Okay. That is the trick. That is the trick. All right. Now, if you look at this particular point, the answer is given in this paragraph. It is written that provided also that any subsequent registration of charge shall not prejudice any right acquired in respect of any property before the charge is actually registered. Actually, this paragraph is trying to say that if you had not created the charge, or if you are subsequently creating the charge, then liability will remain intact. It is written that it will not prejudice to any right acquired by the charge holder. So rights of the charge holder will remain same. But this paragraph is about the subsequent registration. So my question is, if charge was not created earlier, but it is created after uh, paying the late fees, so right of the lender will be same or it will be different? rights of the lender will be same or it will be different? What's your answer? Rights of the lender क्या रहेगा? Same रहेगा, different रहेगा? बताओ. So it will be same. But here the point is again, if charge is not created at all, there may be the circumstances when the charge is not created at all. In that circumstances, guys, SBI, contract, all the conditions don't apply. That means SBI can claim the liability, but as being unsecured creditor, because if the charge is not registered, is equal to it is no charge, is equal to it is no charge. If charge is not registered, it will be considered as good as it is not, it is no charge. All right, students, I want to just confirm from you that are you people clear with this section 77? Hello? Are you clear with this? All right. So if they miss the deadlines, can they cancel the contract and create the new one? That is depends upon the parties, Jayesh. Why should law interfere in your personal matter? So obviously, it is actually up to them. If they want to, it's fine. If they do not want to, it is also fine. Law generally does not interfere in the matter. अरे भाई करना हो तो करो वरना मत करो. Yeah, if they are making the fresh contract by canceling the old one, obviously 30 days will be started from the beginning. But understand, creating the new contract means paying new stamp duty to the state government. And the contract what you cancelled, you are not going to get the refund of the old contract, old stamp value. And stamp value depends upon your contract value. I think you know that, right? Fine. So that's what, again, you have to make everything, you have to make again. Everything you have to make. Okay. Now, next question over here is what is the modification of charge? What is the modification of charge? And just a second. Okay, you tell me what is modification of charge? Hmm? Arey bhai, right now I just stated now what is the modification of charge? It simply means mo modification, modification, modified. Yeah, I just now told now it is nothing but when you are changing, when you are changing the terms and conditions, when you are changing the terms and conditions, when you are changing the terms and conditions of the existing contract, it is called the modification. So your voice was breaking, so I, oh my God, am I audible properly? Please confirm, bhai. Am I audible properly? I hope my microphone is working fine. Okay, now you are. No problem. All right. So if you are changing the terms and the conditions of the contract, and if you are intimating the ROC, that is called the modification. But the question is, what is the process of modification? What is the process of modification? Now, this is the question. If this is there in your exam, then students are very much confused. Because registration is very much easy to find, but अब ये क्या बला है भाई? What do you mean by modification? Okay, the answer is here. Try to understand. Look at. If you come to this particular thing, what is written over here? On payment of such fees and such manner as may be prescribed. As may be prescribed. So look, this is the provision, section 77. This is the provision of the act. But when I say as may be prescribed, these are the rules. And I think all of you know in this classroom that the rules of the company law and provisions are totally different. Provision says what to do and rules are stating about how to do. Are you people aware about that? Rules means procedures. You tell me the form CHG1 and CHG9, is it written in provision or it is written in the rules? If you look at this, you read the entire section 77. And this is not my words. These are the governmental website. This is the governmental website. You tell me the form number CHG1 and CHG9, is it mentioned in the provision or it is mentioned in the separate rules? I am asking to the whole class. Tell me, is it mentioned in the provision or it is mentioned in the rules? It is mentioned in the rules. And you know, government is very smart. They said if you want to change the act, we need to go to parliament. But if you want to change the rules, you don't need to go to parliament. The rules can be changed by the government at any point of time. For example, if they want to modify the name of the forms, do they need to pass the consent in the parliament? Answer is no. Got it? So, as we prescribed, if you click on this particular link, look, rule number 3 provides what is written? Registration of creation or modification of charge. This word is very important. Creation or modification. What is written in that? Are you able to see this? Are you able to see this? ठीक है. So for registration of charge as provided in section 77, 78 and 79, 78, 79 I will take later on. The particulars of the charge together with a copy of the instrument, if any, creating or modifying the charge in form number CHG1 or CHG9, as the case may be, duly signed by both the parties, it shall be filed with the ROC within a period of 30 days from the date of creation or modification. Further, it says that if the particular of charge are not filed in accordance with this point, that means within 30 days, within the period as specified under section 77, on payment of okay, before I go, read this point. If the particulars of charge are not filed in accordance with the subrule, whether for creation or modification, then you have to pay the additional fees or the ad valorem fees as per the rules. As per the rules. What you people have concluded out of this reading? Can you observe every time when I'm reading this paragraph, these two words are together, creation or modification. Look at this, creation or modification. Look at this now, registration or creating or modifying. So what is the conclusion? What is the conclusion? Can I say that procedure procedure of creation is equal to procedure of modification. Hello? Creation means, I hope you are able to understand, right? So whatever registration process we use for the creation, same registration process will be used while you're changing the terms and conditions. So students, do not get confused. Do not get confused. What am I trying to say? Understand that creation as well as modification procedures of both the things are totally same. Procedures are same. So guys, do not get confused. Again, the same thing. If you want to register the modification, same procedure. First of all, you have 30 days. And if you couldn't have done that within 30 days, what are the next points? Hello? If you could not do within 30 days, then 30, no, not 300, Mahima. It is 60 from creation. Remember the amendment, because now we are understanding after amendment. And for that, you have to pay ad valorem duty. And all of you know what is ad valorem duty, right? All of you know what is ad valorem duty. So this is how the things can happen. This is how the things can happen. I hope you're clear with the. Come on, it is not Shamika cancellation of the previous class. It is the replacement, beta. It is the replacement. It is the substitution. It's not a cancellation. All right. Will you take 5 minutes break or should I continue today? Because then I would like to go with the section number 78. Take 5 minutes. All right, welcome back. I hope you're freshen up and now we can start. Are you ready? I hope you're good to go once you're ready. Fine. All right. So let's now do the next section, and that is the section number 78. Now, trust me, guys, in this entire chapter, section 77 was one of the most lengthiest section. Remaining section are not that much lengthy, and even the explanation is not that much lengthy in understanding. Fine. So let's go with the section 78. And what the section 78 is talking about. Application for registration of charge. If you read this particular beginning of the section, it says that where a company fails to register. If you can see over here, the sentence is starting with the word where a company fails to register. Are you able to see this? Where company fails to register. So the question is like, you know that a charge can be registered by both the parties. Either it can be registered by company or it can be registered by charge holder. Generally, it is the prime duty of the company to register this. But in case if it doesn't register, can charge holder register? Obviously, yes. But ROC is more close to whom? If I'm asking you, ROC is more close to whom? To the company or to the charge holder? To the company, you know that. ROC. Okay, okay. In order to understand this thing, let's take an example. Suppose at one day, Mr. Jayesh, who is a close friend of Mr. Milan, goes to Milan's father and says that, Uncle, Milan has asked for 25,000 rupees. He's in the trouble right now. He wants to pay his college fees. Uncle, please give me 25,000 rupees. Now Jayesh is unknown to father. Will father of Milan will directly pay 25,000 to Jayesh, or before paying 25,000 he will inquire with Milan by calling him that really have you sent anyone, or really he deserves to get 25,000? Answer the question. Whether father will directly give the money or he will inquire before paying the money. So it is common sense. It is common sense that father, obviously father of Jayesh will inquire first of all that really Jayesh has asked for the money or not. Sorry, whether really Milan has asked for it or not. So he will call to Milan, and if he confirms, then and only then father will pay this 25,000 rupees to Jayesh, otherwise not. So same thing is over here. So suppose there is a company now, instead of Milan, let me take the new name company. In place of Jayesh, let me take over here the lender, that is the charge holder. All right, I'm just changing the characteristics, and father is ROC. So if charge holder directly goes to ROC and states that company has taken the loan from me and registered this much charge in my favor, will ROC directly register or it will inquire first of all? Because you understand, if company comes to ROC, there is no doubtful situation. Are you getting my point? If Milan goes to father and asking for 25,000 rupees, there is no doubtful situation. But if Jayesh, who is unknown to father, if he goes, it is suspicious. Same way, if company itself goes to father, company itself goes to the father, sorry, I'm sorry, company itself goes to ROC, there is no problem. ROC will register. But if charge holder says that I have given the loan and please sign, register the charge, don't you think it is problematic? Hello? Don't you think it is doubtful? And that is why ROC will not register until it inquire first. And that is the question under section 78. Section 78. So section 78 talks about that how it will go. So according to section 78, here law says that ROC will inquire, but how this inquiry will be conducted? How this inquiry will be conducted? All right. How this inquiry will be conducted? So answer is quite simple. ROC will issue the notice to the company. What it will do? It will issue one notice. All right. ROC will issue notice to the company demanding its justification within 14 days, asking that charge holder has filed this form. Have you really given your consent or not? If company says yes, I have given the consent, ROC will register the charge. If company says no, I did not give my consent, ROC will not register the charge. What if company remains silent? Company neither said yes nor said no. It remains silent within 14 days. So if ROC finds that no response is received from the company within this much time, so charge may be registered by the company or ROC, right? So if company doesn't respond within 14 days, then ROC may register. ROC may register the charge. And that is only the explanation given under section 78. Hey, type the word clear if you have understood this much. Come on. All right. Okay, then you look at what is written over here, section 78. Just have a look at the words. It is written that where a company fails to register within the period of 30 days without prejudice to its liability in respect of any offense under the chapter, the person in whose favor the charge is created may apply to the registrar. That means here we are talking about charge holder for registration of the charge, along with the instrument creating for the charge within such time as it is provided within a period of, okay. Now this is very important. The registrar may on such application within a period of 14 days after giving notice to the company, unless the company itself registers the charge or shows sufficient cause why such charge should not be registered, allow such registration on the payment of the fees. So if after giving the notice within 14 days, if ROC finds it convenient, it can register the charge. So guys, I hope the section 78 concept is clear in everyone's mind. Hello, you can type the word clear if you got to this. Fine. So that is section number 78. Section number 78. I want all of you just to have the snapshot of this particular provision. This is the latest provision. Latest provision. Take the snapshot, or if you do not want to go with the snapshot, should I give you the link of this ebook? Do you want this ebook link so that you can just refer in my absence? Look at this. Click on this. You will get it. Right? Copy it. So after that, I want to go with the another section number, that is the section number 77. Sorry, 79. That section 77 applies on what? So guys, this is sorry, section 79 is stating that 77 is applicable for company which is creating the charge and to a company which is modifying the charge. So procedure as mentioned under section 77, it is applicable under these two particular procedure when company creates the charge, when company modifies the charge. I think this point already we have covered up under the modification of charge, isn't it? Hello? This point already we have covered up under the modification of charge, right? So again, guys, if you want to take the snapshot of this, you are allowed, or I can paste. What I will do is I will paste in the chat box if you want to copy that. तो आप यहाँ से भी copy कर सकते हैं. आप लोग यहाँ से भी copy कर सकते हैं. ठीक है? All right. What I was thinking, I have just one idea. A lot of notes I'm writing over here, but the notes are not reaching to the students because you can just see the image format, you cannot copy it. So do you suggest any mechanism where if I type over here, you can directly copy there? That mechanism is, what if I share this Excel file in Google's spreadsheet? Then how it is, if whatever I typing over here, it will go to Google Cloud, and if that file is shared to all of you, you can directly copy the contents even in the live class, if I'm not wrong, right? So do you want me to implement the technology in your class where whatever I'm pasting here, whatever I'm showing here, directly you can copy to another Word file or wherever you want. Let me try on this. Fine. Next section over here, it is the section number 80. Section number 80. And section number 80 is very important. I want all of you that make it 5 stars to this particular section, because if ICI wants to ask a question based upon section 80, what already they have asked, question can be, okay, I have the question. Wait. I have the question. Look at this. The next question what I'm going to solve is about this only. And this question is very much practical to section number 80. Now, how to provide it? Uh, just a second. Let me have this. Yeah, this is fine. किधर गया भाई? ये रहा. Read this question, and automatically this question, you will understand that how section 80 applies to this question. Okay? What is written over here? This is the May 17 RTP. This question belongs to May 17 RTP. Okay. So Mr. Antriksh entered into an agreement for purchasing a commercial property in Delhi belonging to NRT Limited. So भाई क्या हो रहा है यहाँ पे एक person है Mr. Antriksh करके and he is buying a property from the another company called NRT Limited. All right. Further, it is written that at the time of registration, Mr. Antriksh comes to know that the title deed of the company is not free. That means the property is not free. Not free means what? It is already mortgaged. It is already mortgaged with someone. That is called the title is not free. And the company expresses its inability to get the title deed transferred in the name of Mr. Antriksh, saying that he ought to have had the knowledge of the charge created on the property of the company. You tell me, Mr. A and NRT Limited, these two had the contract to buy the property, but already the company's property was secured with someone else. So can I say company had already charge created on the assets? Company got the charge created on the assets even before making this contract. Can I say like that? Can I say like that? That company had the charge created already before entering into this contract. You can type the word yes or no. Hello? Come on. Yes. All right. So what is the company's argument? Company's argument is Mr. A should have had the knowledge about the charge created by the party. He says, how would I know? It is your duty to tell. So that is the matter of dispute. Is it the duty of A to know about the charge, or it is the duty of company to say about the charge? That is the question. Answer it. Is it the duty of A or is it the duty of company? बताओ क्या होगा? Whose duty? And this entire question is about that. Like before I start telling this, are you people clear with the question? Answer को तो बाद में अपन करेंगे. You tell me. Are you clear with the question first of all? All of you? Hello? Only one student is answering yes. What about others? Are you clear with? ठीक है. So what is the answer? So technically the answer is given under section 18. Let's read the section 18. And once you read the section 18, guys, this question can easily be answered. What is written here? It says that where any charge on any property or assets of a company or any of its undertakings is registered under section 77. You tell me information of charge is a private information or public information? Answer the question. Can we see the charges created in that master data in the ROC website? Can we see this or not? So fundamentally, this information is publicly available. What is written further? Any person acquiring such property, assets, and undertakings or part thereof, or any share or interest therein shall be deemed to have notice. Notice here means knowledge, okay? Deemed to have knowledge of the charge from the date of such registration. So anyone who's dealing with the company, he's deemed to have the knowledge. So can I say this concept is just like the doctrine of constructive notice? That before you are dealing with the company, it is always assumed that you have the knowledge of charge. And look, why it is said, look, the information what we are talking about that is publicly available. Before entering into transactions, it was your duty to inquire about the title of the company. If you did not inquire and company did not tell, it is your mistake. So you tell me, company versus Mr. A, Mr. Antriksh, in this question, who will win the case? Who will win the case? Who will win the case? And the answer to this question will be Mr. Antriksh will not win the case, company will win the case. Don't give the arguments like, sir, it is unfair. Understand what is unfair. When you had an opportunity to inquire, but you became lazy and you did not inquire, that is unfair. So by putting the section number 80 over here, actually law is trying to make you more disciplined. That is the fundamental of the discussion. I hope you are clear. Hello, all of you. So that's all for today, students. I hope you have enjoyed section 77, 78, 79, and section 80 along with the questions. Hope the chart chapter is clear to all of you, right? Hey, just a last question before I conclude. Are you people preparing with the class? Or you people are thinking like अभी तो time है बाद में हो जाएगा? Are you people preparing with me? Parallel revision is must, otherwise you are gone. Otherwise you are gone, students. ठीक है? Good luck.